People versus Zoe Galloway, 25T3675. Ms. Galloway appears in person. Good morning. Let's see, Mr. Contreras appears on behalf of the prosecution. I am a senior judge, Ms. Galloway. Judge Meyer is in a 3-day trial, so I'm just helping her out with her docket since she was unavailable today. We didn't want to continue these matters. And give me 1 second here just to find your file. So I see that the case is 101 days old. You last appeared in court on December 11th. And looks like you did not want to fill out an application for the services of the public defender's office, and you did not want to speak to the prosecution. Is that right?
Well, first of all, I'm here on special appearance.
I don't know what that means.
Okay.
You're not here on a special appearance. You're actually here on a summons issued by.
I am here on
court.
special appearance.
Okay.
And by the way, I also filed a notice of presentment. Unfortunately, it was sitting in the mailbox for about a week.
I don't know what that means.
Okay. Well, it's a conditional acceptance offer.
I don't know what that means.
Okay. Well, the prosecuting party has not yet established mens rea, actus rea, corpus delicti, or provided any proof of an injured party.
That's why we have trials.
Okay.
For the
Well, they have to do that in order to establish subject matter jurisdiction.
Okay.
So,
sounds like we're going to set this case for trial today.
okay. Well, I will only conditionally accept if the prosecuting party develops subject matter jurisdiction. It is officially being questioned, so they have to develop that, and they have to, present actus rea and mens rea.
Yeah, I heard what you said. My question to you is, how do you wish to plead, guilty or not guilty? We're setting this case for trial today.
Okay, so I have a conditional acceptance.
I don't know what that means. All I'm asking you is, how do you wish to plead? If you choose not to answer my question, I'll just enter a not guilty plea on your behalf.
Okay, so
How do you wish to plead?
I will only conditionally accept under the conditions that the prosecuting party within the next 14 days is able to establish all of these
I'm
elements.
denying your request, and I'll enter a not guilty plea on your behalf since you're refusing to do so on your own behalf. And so this is going to be a 1-day trial. The trial will commence on
March 25th at 8 a.m.
March 25th at 8 o'clock in the morning.
So I want to point out that I am
I'm not finished talking. The
So,
pre-trial ready.
I am the only injured
I
party in
am
this
so sorry,
case.
but when I talk,
So-
you don't. When you talk, I don't. The pretrial readiness conference will be on.
19th at 2.
Okay.
Are you a neutral judge in this matter?
Am I what?
A neutral judge in this matter? Or are you
A
on?
neutral judge?
Yes.
I don't know what that means.
You know what neutral means?
I don't know what you're asking.
Are you on the prosecutor's side or are you neutral in this matter?
I am not a prosecutor. I'm not a defense attorney. I'm a senior district court judge assigned.
Are you on the prosecutor's side or are you neutral in this matter?
I just answered your question.
You did not answer my
Okay.
question.
Well, if you're not satisfied, I'm sorry. The motions hearing will be on
Sorry, I need to change that. Pre-trial readiness is March 10th at 2:30.
March 10th at 2:30. The motions hearing will be on
February 27th
At-
at 11.
at 11.
So be aware that I placed a bond on this matter and a notice of presentment.
Okay, thank you. And so let me just recap what we're doing. We are having a jury trial. Right now, you are presumed innocent, and it's the prosecutor who has to prove actus reus and mens rea and all of the elements for the crime that you're charged with to a jury of 6 unanimously beyond a reasonable doubt. That trial will be conducted on March 10th at 2:30 in the afternoon. Excuse me. That trial will be on March 25th, beginning at 8 o'clock. We're going to have a pretrial readiness conference to make sure the parties don't have any last-minute issues. That'll be on March 10th at 2:30. I'm setting a hearing on February 27th at 11 o'clock for any motions that need to be resolved. I'm going to mail to you a pretrial discovery order. And essentially what it says is that the parties need to endorse witnesses within 30 days of today's date. Any motions need to be filed within 30 days of today's date. Any expert witnesses need to be endorsed no later than 30 days prior to the pretrial readiness conference. And again, you'll be receiving a copy of that. Jose, I'll need to send you this.
So the prosecutor needs to be aware they have 14 days to respond to this notice of presentment.
They do not. I'm the one who sets those
Okay.
deadlines, and they do not have to do what you say.
Ubius ibi remedium.
And so
So,
I see that you're currently on a summons, and your summons is continued until the next court date. If you don't show up, a warrant will be issued. Have a nice day. Thank you, Ms. Galloway.
Well, that definitely didn't go the way she expected. The moment she thought she could control the courtroom, the judge quickly reminded her who was actually in charge. He made it very clear that the prosecution didn't have to follow her demands, and the decisions in that courtroom weren't hers to make. Usually, this is the kind of moment where you hope the same judge stays on the case, but luckily, the original judge turned out to be just as strict and unwilling to entertain the nonsense. And that brings us straight into the next hearing, where things only get more interesting.
Are we ready to call Ms. Galloway's case?
Yes, Your Honor.
Okay, the court calls People versus Zoe Galloway, 25T3675. Ms. Galloway appears and is coming forward. Mr. Lemieux appears on behalf of the people. Good afternoon, Ms. Galloway. The case is set.
Evening, Your Honor.
Um,
I'm Zoe G. Kendrika Galloway, and I repent of all my sins, and I'm here on special appearance, not general appearance, and I reserve all rights with explicit reservation. Your Honor, does the court's record reflect that this court is in possession of my valuable negotiable instruments, being acceptances?
So,
then-
Ms. Galloway, first of all, I'm going to ask that you hold on for a moment. Okay, I need to make a record. So, Mr. Lemieux appears on behalf of the people. We are set today for trial readiness. The case is scheduled for trial on March 25th at 8 o'clock. The 3 remaining counts after the court received proof of insurance and dismissed that count are speeding 10 to 19 miles over the speed limit, driving without a license, and driving with fictitious plates. Mr. Lemieux, are the people announcing ready for trial?
People already Your Honor.
Okay. And Mr. Lemieux, have you extended an offer in this case?
We have.
Okay. And just for the record, can you just put that on the record, please?
Your Honor, how is it that this court can retain custody of all the discharge instruments, being my negotiable acceptances, yet still attach charges to my physical body when discharge has already occurred?
So,
Does-
Ms. Galloway, I don't know what any of that means. I know that you filed a number of motions
So-
with the court that make no sense to the court, and I don't know what any of those
Your
things
Honor, how is it
mean.
that you can draw draft instruments on an account that you control, that you have made the prosecutor and junior security interest and accommodation party on, that you
Okay, so
send
Ms.
those
Galloway,
to
I
me?
asked Mr.
and that you
Lemieux
do
a
not
question,
understand
and I'm
what they
waiting
are?
for him to respond to the court, so I'm going to ask that you stop interrupting. Mr. Lemieux, if you could just make a record for the court as to what the offer is that's been extended in this case, so it's clear to Ms. Galloway what the offer was
I guess
or is.
I'm looking at the notes, and it looks like when we tried to convey offers previously, the kind of same thing that happened now just happened again. So I'll just convey the offer here then on the record to plead guilty to speeding 5 to 9 miles over the speed limit. But they said no,
Excuse me,
it's fine.
but does the record reflect I do not plead guilty, but that I plead equity?
Okay, thank you, Ms. Galloway. Please stop interrupting. Everyone gets a chance to talk. Mr. Lemieux, the offer is plead to speeding 5 to 9 miles.
$7 fine, and then plead guilty to expired plates, Your Honor.
Okay. So it sounds as though that's the offer that the people have extended. It's pretty clear, Ms. Galloway, that you're not interested in that. We are set for
Actually, excuse me,
trial.
but does the court's record reflect that I have accepted all presentments and offers of the court, the clerk, and the prosecutor, and I have returned them for discharge of this matter? How is it that this court can retain custody of all those acceptances yet not recognize that discharge has already occurred?
So, Ms. Galloway, the only way that you are entering a plea in this case is if it happens on the record in front of the court.
Does the record
So-
reflect that I plead equity today?
So there's no such thing as pleading equity in this case based on the allegations. If
So
you want
you're-
to accept the DA's offer, you're certainly welcome to do so.
Does the record
I
reflect
would
I
be
have accepted
happy-
and returned all presentments and offers of the prosecutor, the court, and the clerk? And
But Ms.
it-
Galloway, the DA's office has
Mhm.
not filed any plea paperwork with the court that you've signed and returned to the court. I've never been provided any proposed agreement between the parties in this case.
Does
So
the
if
record
you
reflect that
want
I
to
have
accept-
sent my plea of equity to the court, the clerk, and the prosecutor in this matter?
So
and
Ms.
that
Galloway,
do
I
indeed
have
plead equity?
received all of the things that you have filed in this case. They're all reflected in the court file.
Does the court record that I
Again,
did not file anything? And Your Honor, I accept your dishonor in this matter. Does the
Okay.
record reflect I plead equity?
Okay,
And
so
how
Ms.
is it that
Galloway,
you do not
we're set
understand
for
the-
trial then on March 25th at 8 o'clock. I'm not going to go back and forth
Okay.
with you. So clearly you're not accepting the DA's offer, which is absolutely your right. We're scheduled for jury trial on
Does the
March
record reflect I
25th
do
at
accept
8
and
o'clock.
return the DA's offer?
So the DA just explained to the court today that today is the first time that they've ever extended an offer that you have been able to listen to. If you want to accept the DA's offer, I'm happy to pass the case, have you read through some paperwork and recall the case, but plea paperwork has never been filed with this court.
Does the record reflect I hereby accept and return the prosecutor's offer for full settlement and closure of this matter?
So are you wanting to accept the DA's offer to plead guilty to speeding 5 to 9 miles over the speed limit and driving with expired plates?
Does the record reflect that I accept through assent, not consent, and that I have accepted and returned all offers? of
So Ms.
presentments
Galloway,
of the
your
count-
options,
the
if you
court, the
want to
clerk, and the
accept,
prosecutor.
your options, if you want to accept the DA's offer, are to plead guilty or no contest
And what's the other option?
to proceed to trial on March 25th.
And does the record reflect that I plead equity? And if you do not, Your Honor, if you do not understand equity pleading, surely you have a duty and an obligation to recuse yourself and place me before a judge who does understand equity pleading so that I can settle and close this matter today. Does the record reflect that I have honored your court by accepting and returning all presentments and offers? And that this matter has been fully discharged already?
So Ms. Galloway, the matter has not been fully discharged. As I've explained
I
repeatedly.
accept your dishonor.
The DA has extended an offer today. Do you want to accept the DA's offer today?
Does the court's record reflect that I accept by assent, not consent, and I return it in personam to the prosecutor and the judge and the clerk for full settlement and closure of this matter?
Ms. Galloway, would you like to accept the DA's offer today?
Does the record reflect I already answered that question and then I accept by assent, not consent, and I attach it to the prosecutor in personam for full settlement and closure today?
Okay, so the court's going to take that as a no. We're set for
Excuse me, does the
trial
record
on
reflect
March
that the judge is
25th at 8
obfuscating the record
o'clock.
by putting false words into the mouth of the defendant and denying the defendant due process rights?
Ms. Galloway, I'm not denying you any due process rights. We're set for trial. Your options are to accept the DA's offer or to proceed to trial. I'm not going to keep going in circles with you. So Mr. Lemieux, I'm
accept
gonna
and return
impose
trial to
deadlines.
you in personam for full settlement and closure. Judge, I accept your dishonor in this matter for retaining custody of the negotiable instruments, yet not recognizing that discharge has already occurred. Judge, isn't it true that in accordance with the exemption of the constitutional clause, the acceptance is the only means of payment? And that negotiable instruments must be accepted on the face of their value, and therefore
Galloway,
full
this is
settlement
not a
has been-
civil case. This is not a money case involving two parties in a contract. This is a criminal case where there are traffic offenses that have been alleged against you. So again, as I've indicated, if you would like to accept the DA's offer, you are absolutely free to do so. But your options then are to either plead guilty to the two charges as the people have indicated, or for you to plead no contest.
Does the record reflect I plead equity and I return all presentments and all offers to the prosecutor? And Your Honor, I know you and I both know that while this purports to be a criminal matter, it is actually commercial in nature, right? Otherwise, why is there a QSIP number attached to the bonds on this case? And Your Honor, do you have a financial interest in this matter? Isn't it true that this court has already packaged several bonds and attached and handed them off to an indentured trustee to be prepared for securitization on the open market?
Ms. Galloway, you were issued a summons in this case. You've never posted a bond, and this court has absolutely zero financial interest in this case. Mr. Lemieux, the court is going to give the people until March 20th at noon to file your proposed instructions, good faith witness list, and good faith exhibit list. The court will then give Ms. Galloway until March 24th at noon to file any proposed changes to the people's instructions, her good faith witness list, as well as her good faith exhibit list. Ms. Galloway, we're set for trial on March 25th at 8 o'clock. So we'll begin with jury selection. There'll be probably about 30 members of the public here. The parties will both have an opportunity to ask questions of the potential jurors. And then ultimately we'll select a jury. The parties will have the opportunity to select a jury of 6. We'll then proceed to opening statements. The people will then have an opportunity to present any of their evidence. You will have the opportunity to ask questions of any of their witnesses. You'll then have the opportunity to testify yourself, present any witnesses or evidence that you have, and then both sides will have an opportunity to make a closing statement. Do you have any questions generally about how the trial will proceed or any basic trial procedure questions that I can answer for you?
Does the record reflect that I employ my equitable right of rescission and rescission anything that I may have unknowingly acquiesced to in this matter, and that I do indeed plead equity, and that I accept your dishonor and attach trial to you in personam for full settlement and closure of this matter?
Again, Ms. Galloway, I don't know what any of that means. None of those words are criminal terms that are in the statutes or the Constitution of the Colorado Constitution or the federal Constitution. There's no option to plead equity. I don't know what you're referring to. I've explained to you repeatedly what your options are. So at this point, I've imposed deadlines for trial.
Does the record
We'll see
reflect
you
I
back
plead
here
equity and the
on
judge
March
is obfuscating the
25th
record by
at
entering
8
a false plea on behalf of that defendant? And your judge, if you do not understand the negotiable instruments laws of the state of Colorado, the United States of America, and the accounting on this matter, surely you have a duty to recuse yourself of this matter so that I can be put before a judge who does understand equity, so that I can settle and close this matter and bring full honor to your court.
So Ms. Galloway, as I've referred to you repeatedly, as I've explained repeatedly, this is not a civil case. There is no money. There's no negotiable contracts.
Your Honor, are you
can-
trying to overturn
you
hundreds
can
of years of an
file
equity
whatever you would like
jurisprudence?
with the court. The court is following the procedures required of me. So we'll see you back here on March 25th at 8 o'clock for jury trial. Thank you.
I
The
accept your
court is in
dishonor and I return
recess
it back
this
to you in
case.
personam for full settlement and
Ms.
closure.
Galloway, the court's in recess on this case. We'll see you for trial on March 25th at 8 o'clock. Thank you.
And that brings this courtroom battle to an end. What started as a simple traffic case quickly turned into a tense legal showdown as the defendant continued pushing unusual arguments about special appearance, equity, and negotiable instruments. But inside the courtroom, the judge made one thing very clear. The case would move forward under the law, not personal interpretations. Again and again, the court explained the choices on the table: accept the offer that was given, enter a legal plea, or prepare for trial. But instead of a simple resolution, the hearing turned into a back-and-forth exchange, filled with interruptions, challenges, and confusion over the legal process. This case is a reminder that every defendant has the right to defend themselves, but understanding the rules of the courtroom can make the difference between solving a problem and making it much more complicated. Now the question goes to you. Do you think the defendant was standing up for her rights, or did refusing to follow the normal court process only make things worse? Drop your thoughts in the comments below, because everyone sees these courtroom moments differently. If you want to see more real courtroom confrontations, unexpected moments, and cases where one decision can change everything, make sure to follow for the next case.